A lot of ground was covered. So let's begin with the morning and then we'll move on. So as you would recall, yesterday orders were made for the Ministry of Education to produce minutes of the meetings they had with the Guyana Teachers Union. You would have heard me yesterday raise an objection to that course. You would have heard also that the basis upon which the court decided to adopt that course was because the union was saying that they have in their possession minutes which establish that no discussions were had on financial matters. The union was saying that they had no minutes in their possession. They had minutes, but those minutes did not establish that the parties discussed financial matters. And the government was saying that we have minutes saying that financial matters were discussed. The court, rather than order the applicant who has the burden of proving their case, rather than ordering the applicant to produce their minutes, strangely ordered the government to produce their minutes. We produced the minutes as ordered by the court sometime during the course of last night. This morning now, the judge decided to revisit his position as a result of objections I made. Again, objecting to one side being asked to produce minutes. And again, I adverted to what I considered to be a shifting of the burden of proof. The applicant must prove his case. The respondent doesn't have to prove a case. If the respondent doesn't have a case in the court, it's the applicant who filed the proceedings. As a result of those objections, the judge ordered the applicant, the union, to produce their minutes. And when grilled, lo and behold, we were informed that they have no minutes. So the applicant, when they were saying throughout that they have minutes and those minutes establish certain negotiations took place and that certain negotiations did not take place, that was a complete and utter untruth. When they were put to the burden of producing those minutes, they then sheepishly told the court that they had no such minutes. So that's the first point I want to make. The second point I want to make is that the deponent of the affidavit for the union, Mr. Cambridge, took the witness stand and was cross-examined for several hours. And everything that we have been contending all along, we were able to establish it through the mouth and evidence of Cambridge, the vice president of the union. Among the things that we attempted to establish, and which we believe we established, one, that there were regular meetings between the union and the government, the Ministry of Education, ending until the 31st of January. That was established. Secondly, that at those discussions, many dozens of issues were discussed. And they were discussions and bargaining as unions and employers do. That coming out of those engagements, dozens of measures proposed by the union were implemented by the Ministry of Education. That dozens of those measures have a financial impact. They include duty-free concessions for teachers. They include remunerative allowances for teachers. They included traveling allowances for teachers. They include training allowances for teachers. They include house lot allocations for teachers. They include a whole host of measures, all of which have a financial impact on the welfare of teachers. So when we are saying that financial matters were discussed, through the witness of the GTU, we were able to establish that, I believe, to the satisfaction of the court. Significantly, what we were able to also bring out clearly and emphatically is that there were many, many measures which the union was asking for, but they were asking only for it to be granted to their members. And you were in court from the beginning, and you would have heard how many times the witness had to admit that the proposals which came from the union related only to members. In granting those measures, did not grant it only to members of the union, but granted to teachers across the board. So we tried to establish, or someone tried to establish, that strike talks were part of the January 31st, 2024 meeting between the union and the Ministry of Education. The minutes of those meetings were examined, and nothing about a strike or anything of that nature was talked about. In fact, what the minutes established was that Mr. Light thanked the ministry for the productive engagements that they have had over the past few years and expressed the hope and expectation that it will continue. And he made the emphatic and specific point that the teachers and the teachers' union benefited significantly from those engagements. So what you have had is a dismantling of this notion that there is no collective bargaining and no collective bargaining was taking place. You have a clear narrative of an engagement between the union and the employer, the Ministry of Education, on behalf of the government of Guyana. Through that engagement, as normal engagement between trade unions and employers it produced a number of decisions and measures which were implemented. We now have Mr. Saddam Hussein in the witness box, and his cross-examination has just begun. Of course, they're going to, but you saw the cross-examination already directed to Mr. Saddam Hussein being asked to show minutes and discussions relating to salary increase. So that's where we are, and the case is to continue tomorrow for Mr. Hussein to continue to be subject to cross-examination.
You asked for a date for fixed application.
And after tomorrow, I have asked that the matter be adjourned for a week because I would not be in the country for a week.
Thank you.